most obvious case is where cohabitees both contribute towards the purchase of a house without an express declaration of trust, and then they split up. That's usually what people are referring to when they talk about Talata proceedings. And by Talata proceedings, I mean an application under the Trusts of Land and Appointments of Trustees Act. Section 14 allows the court to determine the beneficial interests of land held on a trust of land and to make an order for sale. However, the same questions might arise where, for example, one of the cohabitees dies without leaving a will. If the deceased cohabitee was the sole owner of the property, it will fall into her estate, and the cohabitee will get nothing under the rules of intestacy. But he could bring Talata proceedings to determine what portion of the land belonged to him, and he could combine this with Inheritance Act proceedings under the 1975 Act. Another common example would be where a sole owner goes bankrupt and the trustee in bankruptcy applies for an order for sale of the property for the benefit of the creditors. The partner or cohabitee of the bankrupt can then apply for a determination that part of the property was held on trust for him or her and therefore is not available to the creditors. And then a further example would be where two or more people purchase a property together as a business venture and they make unequal contributions. The list goes on. There are many different circumstances where it might be necessary to make a determination of the beneficial interests in land. Let me begin with some basic statements about law and equity. First, if one person is the sole owner of both the legal and beneficial interest in a property, there is no separate equitable interest. Lord Brown Wilkinson stated in Westdeutsche Landesbank in Islington that unless and until there is a separation of the legal and equitable estates, there is no separate equitable title. That means there is no trust of land unless there is more than one legal owner, or one legal owner, for example, who holds the property on trust for the benefit of others, perhaps including herself. Secondly, a property can be held on trust as beneficial joint tenants or as tenants in common. In short, joint tenants are deemed to constitute a single unit. They own the whole property between themselves. Sorry, participants are raising their hands. Can I just check whether... Okay, there's a question. I'll come back to the questions. The question is, can the court order one party to purchase the share of the joint owner or only determine the extent of the interests? I think what I'll do is I'll come to the questions at the end if they haven't been answered already. Please do let me know if anything if there's any problem with the recording or if you're not hearing me properly. So joint tenants are deemed to constitute a single unit. They all own the property equally and share unity of possession, interest, title, and time. And when one of them dies, their interest passes to the others under the doctrine of survivorship. It's important to note that the only way of owning legal title between co-owners is under a joint tenancy. It's a legal joint tenancy. And then you can also have a beneficial joint tenancy. You could, for example, have 3 legal owners. You can only have 4 joint tenants maximum. So you could have 4 joint tenants of the legal title holding, for example, 5 or 6 for the benefit of 5 or 6 joint tenants. There's no limit to the number of joint tenants you can have in equity. Then in terms of having trouble with my, there we go. In terms of a tenancy in common, tenants in common have undivided shares in the land, which means that their interests are separable. They've severed the joint tenancy in equity, but it's not divided in the sense that they have separate portions of the land there that are allocated to them. It's only when, for example, one of them dies or one of them you want to sell the property and realize their interest, that it's separated out. They are tenants in common, and that distinction is quite important for what we'll come to later. Thirdly, it would be a lot simpler if all transactions to do with land were made in writing and registered with HM Land Registry. But life is too complex and informal for this. We trust our friends and partners, we make handshake deals, we believe promises that people make to us, and we're ignorant of the law. If the law failed to recognize this, it would lead to substantial injustice. And as a result of that, there is a tension between the statutory provisions which require strict formality and those which carve out a space for the more flexible rules of equity. For example, Section 52 of the Law of Property Act 1925 states 1b, a declaration of trust respecting any land or any interest therein must be manifested and proved by some writing signed by some person who is able to declare such trust or by his will. But then there is the exception in subsection 2 that this section does not affect the creation or operation of resulting, implied or constructive trusts. You see the same dynamic in section 2 of the Law of Property Miscellaneous Provisions Act 1989, which relates to the sale or disposition of land by contract, which states the contract must be in writing, incorporating all the terms and so on. But then there's the exception that it doesn't affect the creation of resulting, implied or constructive trusts. So the flexibility and informality of the rules of equity mean that while it is very easy to determine who the legal owner or owners of a piece of land is, determining who the beneficial owners are can be a murky business. It can be entirely off title and not known at all to land registry. Where the beneficial interest is different to the legal interest, this will usually be due to one of the following: express declarations of trust, resulting trusts and the presumption of advancement, constructive trusts, common intention constructive trusts, or proprietary estoppel. I'll deal with all of those apart from proprietary estoppel, which is really a seminar in itself. So turning first to express declarations of trust. Generally, if you want to know who owns a property, you can look at the TR1 transfer form, and you will see box 10, declaration of trust, and you can see there whether the purchasers decided at the outset that they were going to hold it as beneficial joint tenants or as beneficial tenants in common in equal shares, or on some other trust as tenants in common. If you find a declaration of trust there, then that should be conclusive, unless it could be set aside, for example, on the grounds of undue influence, fraud, duress, or rectification. I should also mention that John Randall QC appeared in the case of Clark and Meadus, where it was held that express trusts are not forever immutable. They are capable of being overridden on proprietary estoppel principles as a result of promises and representations made after the trusts were declared. But in an ordinary case, if there is an express declaration of trust, that is conclusive. If there's no express declaration of trust, we need to go on to consider some of the other ways that a trust of land may have been created. 4 participants raised their hands. Can I just check whether there's... Okay, what if there's a question, what if question 10 on TR1 is not completed? I have a case at the moment where the TR1 was left incomplete. Yes, it's not mandatory to complete box 10. And in Stack and Dowden, interestingly, it's noted by Baroness Hale that if it were mandatory, then most of this case law would disappear. We wouldn't have this problem. And in fact, the current form that we have was not actually brought in until April 1998. So there are many cases before 1998 where people would not have made express declaration of trust, they wouldn't have had this form. And if that's the case, then unless they've expressed a declaration of trust in writing some other way or manifested in writing some other way, then you are thrown back on all of these other principles, which we're going to discuss now. Okay. So resulting trusts. Excuse me, I've got a bit of a cough. So I haven't got coronavirus, I don't think. In Westdeutsche Landesbank and Islington, Lord Brown Wilkinson gave the classic statement of resulting trusts, that where A makes a voluntary payment to B, or pays for the purchase of property which is vested in B alone, or in the joint names of A and B, there is a presumption that A did not intend to make a gift to B. The money or property is held on trust for A if he is the sole provider of the money, or in the case of joint purchase by A and B in shares proportionate to their contributions. Now, it's important to note that the presumption of resulting trust is rebuttable. As Snell's equity states, the presumption can be rebutted by proof that A did in fact intend B to take the property as beneficial owner. This intent can be established by direct evidence, or to a degree by reliance on the presumption of advancement. In short, if you pay for property in someone else's name, the court will presume that you were throwing a boomerang rather than a stick. In other words, you did not intend to throw away good money, you intended it to return to you as a beneficial interest in the property. But if there is evidence that the money was given as a gift or as a loan, this will rebut the presumption of resulting trust. Note that a loan creates a contractual debt, not a resulting trust. Well, this brings us on to the question of presumption of advancement. Because the resulting trust presumption can also be rebutted by the presumption of advancement. I can see people have raised their hands. Is there a question here? Let me just check. Not at the moment. And the presumption of advancement works in the opposite way to the resulting trust presumption. The court will presume that you were making a gift, or in my analogy, throwing a stick rather than a boomerang. The presumption of advancement essentially reverses the burden of proof. If the presumption applies, the burden of proof is on the person who made the transfer to rebut it by proving that the transfer was not a gift. But if the presumption does not apply, the burden is on the person who received the transfer to prove that the transfer was a gift. So that raises the question of when the presumption does apply. Snell's equity gives a helpful summary here. It's a relatively old-fashioned doctrine, and so the traditional categories related to where family members, where the recipient B was legally dependent upon A, so that A had a moral duty to support or advance B, and the traditional categories were a transfer from father to child and from husband to wife, not the other way around. But the court may be prepared to draw an inference that a transaction between members of household or family was intended as a gift when that accords with common social experience. The formal presumption of advancement does not apply to transactions between an unmarried couple who live together. But aside from the formal presumption, there is perhaps no compelling reason why an intention to make a gift should not be inferred if the parties are in a lifelong relationship similar to a formal marriage. Excuse me. I did a case where a couple had been married in Islamic law, but not under English law. And a claim was brought by the former wife under Islamic law for various transfers of money which she had made during the marriage to be returned to her. and I was able to defend the claim on the basis of the presumption of advancement, the court held that this was a relationship akin to marriage, and there was this automatic presumption that transfers going back and forth between them when they were married were intended as gifts, and she hadn't been able to rebut that presumption. So in summary, resulting trust principles apply in both commercial and domestic contexts, but they're much less common in domestic contexts for two reasons. First, because the presumption of advancement may negate the presumption of resulting trust, and also because it's just more likely that transactions between close family members are actually intended as gifts. So the presumption of advancement is more easily rebutted with direct evidence in domestic contexts than in commercial contexts. I've got a question here. Could a loan by a parent amount to a resulting trust? What if there is no evidence of the intention of the gift? Yes, it will depend on the evidence. If there's an evidence that it was a loan, then the court will be interpreting that as some sort of contract, and there might be questions of whether there was intention to create legal relations and so on. But you would be approaching that on the basis of a debt and an obligation to repay. If it was just money handed over with no explanation, then there may well, depending on the circumstances of whether the child was, how old the child was, whether they're dependent with moral duty to support and so on, there may well be a presumption of advancement, and so it would be for the parent to show that that doesn't apply and that it wasn't intended to be a gift, and they could rebut that with evidence that it was actually a loan intended to be repaid. So next, constructive trusts. What's the difference between a resulting and a constructive trust? Lord Millett explained the distinction in this way. A constructive trust, and this is, I should say, extrajudicial, this is an article he wrote. He is really the don on equity amongst judicial commentators. He wrote that a constructive trust arises whenever the circumstances are such that it would be unconscionable for the legal owner of the title to assert his own beneficial interest and deny the beneficial interest of another. By contrast, the resulting trust also arises by operation of law, but in very different circumstances. It arises whenever the legal title has been transferred to another and the person who provided it did not intend to pass the whole beneficial interest to the recipient. The recipient is bound by the trust even if he honestly believed himself to be absolutely and beneficially entitled to property transferred to him by way of outright gift. His conscience may be clear. So constructive trusts arise in a wide variety of circumstances where it would be unconscionable for the legal owner to assert his own beneficial interest and deny the beneficial interest of another. And that principle of unconscionability is important. It's not necessarily present in resulting trust cases. For a constructive trust claim to succeed, you really want the court to be having this type of reaction to the facts. An example of a commercial constructive trust case would be Match, Move and Dowding. Here the parties were in negotiations over the purchase of a property. The claimant handed over the purchase price in advance of a contract being signed. So there was no Section 2 compliant contract for the sale of this interest in land. The parties were good friends, or the director of the company and the other defendant were good friends going back 10 years, and so there was an element of trust between them. Well, that trust was broken when the defendant refused to transfer the property, having received the purchase price. In this case, as I understand it, resulting trusts wouldn't work because the intention was to give the money to the defendant who was supposed to be beneficially transferred, but on the basis that he would be getting land in exchange. But the court upheld this agreement despite it not having a Section 2 compliant contract on the basis of proprietary estoppel and constructive trust. Now that is quite different to the type of law which is applied in the case of cohabiting couples. The courts in these types of cases have developed a separate body of law called common intention constructive trusts. And unlike with resulting trusts, the focus is not on a mathematical analysis of how much each party contributed. Instead, the court will examine all the circumstances of the party's domestic arrangement. The first question is, who has legal title? Because there is a distinction between joint name cases and sole name cases. In joint name cases, where the parties have declared their respective interests in a written declaration of trust, that will be conclusive, subject to what I've said before. Where the parties purchase a property in joint names without expressly declaring their respective interests, there's a presumption that they hold the property on trust for themselves as beneficial joint tenants on common intention constructive trust principles. So the courts essentially will assume that if you're in this close type of relationship, even if you've contributed unequally, if you bought it in joint names without stating how you own it, then you're presumed that you intended to be a single entity owning this property, and that if one of you dies, it will go to the other. That's the starting point. But that presumption can be rebutted by evidence that they had a different common intention, and the court has a wide discretion to ascertain what the party's common intention was based on the whole course of conduct between them. And if you've got any cases like this, I highly recommend that you get Stack and Dowden and read Baroness Hale's judgment in particular. At paragraph 69, she gives a long list of the factors which will be relevant. For example, advice or discussions at the time of transfer, the reasons why the home was acquired in joint names, the purpose for which the home was acquired, the nature of the parties' relationship, whether they had children. This one is quite important, how the purchase was financed, both initially and subsequently. Did one person pay for the home on the basis that the other would pay for the mortgage? This one is also important, how the parties arranged their finances, whether separately or together, or a bit of both. In Stack and Dowden, it was held that the fact that the parties kept their finances strictly separate, even though they'd been together for many, many years and had children, was a very good reason for presuming that they did not intend to hold the property as beneficial joint tenants, that they intended it to be tenants in common and in unequal shares. Other factors would be how they discharged the outgoings on the property and other household expenses. And she notes that mercenary considerations may be more to the fore than they would be in a marriage, but it should not be assumed that they always take pride of place over natural love and affection. So evidence of strong love and affection between the couple will go a long way to assisting to show that they intended to hold as beneficial tenants in common. Now, in the case of sole name purchases, there is a presumption that the legal owner has 100% of the beneficial interest. In other words, that there is no trust of land. And accordingly, there are two stages to any claim by a non-legal owner. First, the court must determine whether the non-legal owner has a beneficial interest in the property. If he does, it must then quantify that interest. In relation to the first stage, an interest in the property can be determined in two different ways. First, by an express common intention constructive trust, and secondly, by an inferred common intention constructive trust. So for an express common intention constructive trust to arise, there must usually have been an express discussion about ownership followed by detrimental reliance by the non-legal owner. The discussion must be about ownership a discussion such as we own it 50-50 or it's half yours, using expressions such as it's our home, we share a family home, you and the children will be looked after, your financial future is secure. In various cases, that's been held not to be enough. Now, you may notice here that where you're dealing with a sole name case, the factors that the court looks at has much more of a flavour of unconscionability about it. It's almost a bit sort of proprietary estoppel-like, because you're trying to show why that a person who solely owns the property should have to share in that ownership at all with someone else who's not a legal owner. Now, if there's not been any express discussions or assurances, the court can still infer a common intention by looking at the course of conduct between the parties. Traditionally, only a contribution to the deposit or the mortgage was sufficient. Now, this would be the usual type of cohabitee tolata claim, where one of the owners provides something towards the contribution, towards the purchase of the property, despite not being put on the title to the land. And Lord Bridge, in an old case now, said that direct contributions, whether initially or by payment of the mortgage, will readily justify the inference, but it is doubtful if anything less will do. The law has substantially moved on from the restrictive position. Lady Hale and Abbott made that statement, and it's no longer strictly necessary to make a contribution to the deposit or the mortgage in order to establish a beneficial interest. Now, before I move on, I'm just going to look at a question. If a property is purchased solely, TR1 Section 10 completed, purely for the fact that the other party was a bankruptcy, but the bankruptcy contributed towards purchase and paid mortgage for a number of years, worth a shot. I'm going to come back to that because it's not directly related to this. Remind me to come back to question 4 and question 1 as well. However, so turning back to Abbott and Abbott, despite the expectation of a more flexible approach following Abbott and Abbott, the courts have suggested that non-financial contributions by themselves may only count in exceptional circumstances. So to give some examples, there was no common intention constructive trust where a non-legal owner gave up work to look after children, or performing the role of a traditional wife, or where a non-legal owner assisted the legal owner in his business because he said he would look after her. So those cases really do have that feeling of proprietary estoppel. You're almost looking at similar facts to that, but it's not proprietary estoppel. So if the non-legal owner is able to determine the size of that they have an interest in the property, the court will then quantify that interest. And it will do so by taking a holistic approach and considering the whole course of conduct and the stack endowment factors, which I mentioned before, which are well summarized in Baroness Hale's judgment, will be applicable also to determining the size of that interest. So in summary then, where you've got a joint name case, the court will presume that that equity follows the law and that they hold it as beneficial joint tenants in equity and in law. But it will look at the whole course of conduct to determine whether, in fact, the parties intended to hold otherwise, for example, as tenants in common or as tenants in common in unequal shares. If it's a sole name case, the presumption is that there's no trust of land at all and that the legal owner has 100% of the beneficial interest. The court will need to determine whether there was some common intention, expressly implied or inferred from the facts, that was not actually the case, and that the non-legal owner was intended to have an interest. If he or she does, then the court will quantify it based on the whole course of conduct. I'm going to look at some questions now. So let's go back up to question 1. Can the court order one party to purchase the share of the joint owner or only determine the extent of the interests? So under a tolata application, you can apply for both the determination of the interest that each party has under the trust of land, and also an order for sale. And also you could apply for an order that one of the parties purchase the interest of the others at a price to be determined. And there's a recent case law that that price does not necessarily need to be the market value, it's for the court to determine. Next question 4. If a property is purchased solely, TR1 completed purely for the fact that the other party was bankruptcy, but the bankruptcy contributed towards the purchase and paid mortgage for a number of years, worth a shot. I'm not quite sure if I understand the question, but is this a question about whether the bankrupt could try to avoid his or her creditors by essentially a transaction which tries to avoid by a transaction at an undervalue? If so, then that can be set aside under the Insolvency Act. You can bring an application in relation to a transaction at an undervalue, which was made with the intention of avoiding potential creditors. But there may be many genuine cases where that wouldn't be a transaction at undervalue with that intention. Tell me if I've misunderstood your question. Will the recording of the seminar be made available after it finishes? Yes. Hi. Hello, Kevin. Back to question 1. Yes, answer question 1. So those are all questions. Okay. There's another question. Are you saying the court can compel one party to buy, sell others' interests? Yes, it can. There may be reasons why it would be unjust to order a property to be sold. I mean, the classic case where it would be unfair would be in, say, a farming partnership where the house has been in the family for a very long time, and one of them is using it for his livelihood and making money from it. And the fact that one of the other partners wants to leave shouldn't justify selling the whole farm, but the court could determine that the remaining partner purchased the other one's interest. Okay. Now I'm going to move to a little case study. So since 1990, Amelia and Rafe had lived together in the townhouse, which they owned in joint names as joint beneficial tenants. There was no declaration of trust. Since 2000, they sold it and used the proceeds of sale to buy the cottage. When they bought the cottage, Rafe had run up substantial personal debts in a failed business venture. He was worried about going bankrupt. By contrast, Amelia had just received a large inheritance. Amelia and Rafe bought the cottage in Amelia's sole name, and Amelia put her inheritance towards the deposit. However, she told Rafe, "Don't worry, what's mine is yours. We'll still own the cottage 50-50. And the proceeds of sale were 50-50 of the purchase price, so the proceeds of sale of the townhouse, and the inheritance was 25%. Amelia took out an interest-only mortgage for the remaining 25%. The parties had a joint bank account and contributed what they could to the joint finances. Rafe devoted substantial time and effort and £5,000 of his salary renovating the cottage. This increased its value by 10%. In 2017, Amelia and Rafe broke up. Amelia asked Rafe to leave the cottage and they closed the joint account. At this point, Amelia's business was failing and she was at risk of bankruptcy, whereas Rafe, who had managed to avoid becoming insolvent, was flourishing. Rafe wanted the cottage to be sold, but Amelia refused. To prevent the cottage being repossessed, Rafe paid off the mortgage using an inheritance he had received after the separation. And in 2019, Amelia was declared bankrupt. Her trustee in bankruptcy is considering making a Section 325A application for an order for sale and wants answers to the following questions. Let's see whether this poll works. Launch polling. So the first question is the cottage held on a trust of land? Do you want to vote on that question? So at the moment, no one has voted. I don't know whether you're being reticent or whether there's a problem with the way I've got the polling set up. One person's voted, so we got. Oh, here we go. We're off. Don't worry about the second and third questions for the moment. If you don't, you can hold on to those if you want. So I'm just going to leave a couple more seconds. So, right then, the first question, is the cottage held on trust of land? And of course, the cottage is owned in Amelia's sole name. So the presumption is that she is the sole legal owner as well. But the townhouse was held by the parties as joint beneficial tenants, and the presumption was that it was held in equal shares. Now, when they bought the property, the cottage in Amelia's sole name, the presumption that she owned the entire interest will readily be set aside, or there'll be a different common intention because of Amelia's express assurance, I would say, that they shared the equity 50-50. So we got a good, clear statement of an express common intention there. And then Rafe also detrimentally relied on that by putting in his share of the townhouse proceeds of sale towards the cottage, and he also helped to renovate the cottage at expense, his own expense. So therefore, there would be a trust of land within the definition of Section 14 of the Trust of Land and Appointments of Trustees Act. It is likely that Amelia holds the property on trust for herself and Rafe as tenants in common in shares to be determined. Next question is, what was the size of Rafe's beneficial interest at separation? By the way, are you able to see the results? I didn't say. So 90% of people said yes, the cottage was held on trust of land. And question 2, 13% say 1/3, 52% say 1/2, and 36% say another. Well, in this case, Amelia contributed 50% of the purchase price, and Rafe contributed 25%. Or in other words, Amelia provided 2/3 of the equity, and Rafe provided a further 1/3. However, considering all the circumstances, it's not unlikely that the court would find that their common intention was that Amelia would hold the cottage on trust for them both in equal shares, because Amelia made an express assurance to that effect. Rafe relied on that assurance by contributing 1/3 of the equity and carrying out substantial renovations at his own expense. The parties were in a long-term loving relationship, and they had a joint account and contributed what they could to the joint finances. So I think that there is a fairly good chance that the court would say, well, at the point that you separated, this was a case of a 50-50 share. Not sure whether it would be as tenants in common or as joint tenants, but certainly the express assurance given by Amelia was that it would be held as 50-50. Next, can Rafe get an equitable account in respect to the funds he used to pay off the mortgage? Now, you may remember that Amelia used her inheritance as part of the initial purchase price for the cottage, and then Rafe used his to pay off the remainder of the mortgage. And so you might think, well, that balances out, doesn't it? They both contributed 25% from an inheritance. Now, 78% of people say that Rafe can get an equitable account, and 22% say no. I think the key point here is that a constructive trust can be ambulatory, and the in common intention can therefore change. and it's likely that the parties' shares in the property crystallized when they separated. At that point, the court is no longer looking at this as a cohabitee type case where all of those factors apply. It may determine that when Rafe paid off the remaining mortgage, he did not intend to make a gift to Amelia. And it might be at that case that the court will be much more influenced by a resulting trust type analysis that he was not intending to make a gift to Amelia at a point at which they were no longer partners. Therefore, it's possible that on a sale of the cottage, she would have to account to him for half of the capital repayment that he made. So, for example, if he repaid 10% of the equity, Amelia and Rafe's shares would be adjusted from 50-50 to 45-55 in favor of Rafe. So when you're doing an equitable account, you take half of the contribution, because Rafe would have had to contribute half anyway if he was a joint owner, and so you take half of that. So it is possible, therefore, that Rafe could come away with slightly more than Amelia on these facts. Oh dear, we've got lots of questions now. Let me go through these before we finish then. What's your experience of written declarations of trust, sham documents coming to light when nothing is recorded on the transfer and or title to the property? Yes, well, I am doing a difficult case at the moment where it was expressly a sham. In other words, the parties purchased this, well, certainly my client says that he purchased a property with his uncle, and he gave his uncle some money to pretend as if he was putting it towards the purchase of the property, so that it would look as if they were intended to own equal shares in this property. But the whole point of it was that my client was expecting to get divorced, and he wanted to avoid any claim that his wife might have to the equity. Now, subsequently, the uncle has said, no, that wasn't a sham. In fact, that was my money I put towards it. And so I genuinely do have an interest in this property. My client, however, didn't get divorced, and now he wants to state that he was the sole owner all along. So it's a complete mess. There is a TR1 which was produced by the uncle, but it was not signed by my client, and now it's been lost. So yes, that things can get very, very messy very quickly, and it can be incredibly difficult to pick through all of the different facts to determine exactly what is the correct situation. And that's the problem with the flexibility of equity, that you can't just go by by the strict legal interests. Hi, John. You may be about to cover this, but I wondered how many of these principles might apply in corporates, for instance, group companies. I would imagine generally with corporate and group companies that everything will be stated expressly in contracts, and that it will be tied up. But there are many cases where parties have companies that they're making purchases through, and that it is fairly informal. In that case, I think resulting trust principles, proprietary estoppel, constructive trusts would potentially apply. Obviously, common intention constructive trusts won't, but there'll be much more mathematical analysis, and the court will not presume a beneficial joint tenancy because it's stated somewhere that the doctrine of survivorship has no place in business. So, for example, with partnerships, there'll be no presumption of beneficial joint tenancy, that if one partner dies, the other interest goes to the other partner in a business partnership. On position re non-financial contributions being exceptional, James and Thomas, does this apply to an inference of an agreement only, or would it only apply to detrimental reliance? I believe the James and Thomas case was one where there was no express agreement. And so you're looking for something short of an express agreement, but which would justify a finding that the non-legal owner has an interest in the property. And it is difficult to find that type of case. So if there's been no express agreement or no contribution towards the purchase price, then it is quite hard to establish a beneficial interest. There are cases where that's happened. I can't recall the facts offhand at the moment, but it's not impossible. What would the position be where property purchased pre-1990 in 4 names, family unit, parents die, property passes to the 2 children? One of them pay the pairs. I think with these other questions, because they are the final 2 questions are slightly longer, and I'm just looking at the time now, but it's 9:49. I've gone well over the half an hour. So what I might do is, if you could email me those questions, then I can get back to you. My email address is Jaldis, Jaldis, at st-phillips with 1 L .com. Jaldis at stphillips.com. But probably best if I don't try to answer those on the hoof, especially given the time. So I think I'll end the webinar there. I'm very grateful for all of you attending. I hope you have a wonderful day and bank holiday weekend, and all my best wishes for the continued lockdown.